So what does ICWA require if the answer to the question is yes? If someone tells you the child is affiliated with a particular tribe, or that one of their parents or ancestors was Native American, the second part of ICWA immediately is required. The ICWA representatives from the tribe of origin must be contacted right away and informed that DSS may have a child who is a member of their tribe. It's okay if the person reporting is unsure if the child is a registered member of a tribe. Tribes have different ways of establishing membership. You, as a caseworker, don't need to determine a child's status before contacting the tribe in question. Your job is to supply the tribe with information that can help them determine the child's status in the tribe's own records. The tribe will then determine the child's status and notify the agency of how they wish to proceed. Also, it's good to know that giving a child's information to a tribe they are claimed to be connected with is not a breach of privacy. It is required under ICWA. But America has Indian tribes in every state. Are all tribes covered by ICWA? Currently, only federally recognized tribes are covered by ICWA. If the child is identified as connected with a non-federally recognized tribe, then proceed with the case as you normally would. ICWA protections are not associated with non-federally recognized tribes. In South Carolina, we have one federally recognized tribe, the Catawba Indian Nation, whose reservation is just outside of Rock Hill in the upstate. If you have a child who is or is claimed to be a Catawba, the Catawba Indian Nation must be contacted immediately. If you have a child from a federally recognized tribe outside of our state, then that tribe's ICWA representative should be contacted directly. So, what actions do you take if a child or family member claims enrollment or descent from a federally recognized tribe? First, ask what tribe the child does or may belong to. Then, find out if the tribe is federally recognized. The Bureau of Indian Affairs maintains a website that lists all of the federally recognized tribes. Use it to find out if the tribe in question is federally recognized. Notify the tribe's ICWA representative early in the case. That way, you can coordinate with the tribe during the investigation. Early notification of the tribe's ICWA representative is an informal process. Once the courts are involved, a formal notice must be sent. The notice includes detailed information that needs to be gathered early in the case. Be sure to gather as much information as possible, even if you must speak to several people to find it. This information is important since tribes have different ways of determining membership, and the more family information you have, the easier it may be for a tribe to give a definitive answer on the child's status. In some situations, you may not have all of this information, but even partial information needs to be sent to the tribe of origin's ICWA representative. Use the Bureau of Indian Affairs website to find the ICWA representatives for the tribe of origin. Note that the ICWA representatives are different from the tribal leaders. Follow the instructions on the handout to help you find the list of ICWA representatives for each tribe. Mail the ICWA notice form with the child and family's vital information to the tribe by registered mail, with return receipts requested. It can also be sent by certified mail. Remember, notify the tribe as soon as you have reason to believe the child is eligible for membership in a federally recognized tribe. And send the notice as soon as there is court involvement. You want to get the child connected to their heritage as soon as possible for their well-being, and in order to be ICWA compliant. Also, inform the county's legal department that there is a possible ICWA case right away. Work with the legal department to make sure that the notice is properly sent to the tribe. The notice must be signed by the agency's legal representative. In addition, the case manager must document the possible ICWA eligibility in caps. Always document all ICWA information as thoroughly as possible throughout the life of a case. Always ask the question. If the information you receive is vague and there is no trail to follow, document your efforts and due diligence to explore affiliation with a federally recognized tribe. The DSS State Office Division of Child Welfare Programs and Policies can assist you. Remember, South Carolina's goal is to be 100% ICWA compliant. Follow the law and follow the process. Your DSS attorney is your ally, so don't hesitate to contact them at any time. Part of ICWA compliance includes making active efforts, not just reasonable efforts, to keep the Indian children with their families. Active efforts is a higher standard of proof. What does this mean to the agency? Before the court will order an involuntary foster care placement or termination of parental rights, the agency must prove that it made active efforts to prevent the breakup of the Indian family. It must also prove that those efforts were unsuccessful. What does making active efforts mean to you as a caseworker? It means that you need to enlist the tribe's help in meeting the needs of the family. ICWA requires more than routine casework to prevent the breakup of the Indian family. You may need to work with an Indian custodian as well as the parents. An Indian custodian is an Indian person who is caring for the child. The parent may have given the Indian custodian temporary custody of the child, or the Indian custodian may have legal custody under state law or under tribal law or custom. How does the court determine whether active efforts were made? You'll be asked to testify that placement, or TPR, is necessary beyond a reasonable doubt. The court will also consider the testimony of a qualified expert witness. The qualified expert witness must be someone other than the caseworker. The attorneys involved identify the witness, and the tribe has the authority and experience to determine if the individual is qualified. This person studies the case and makes a recommendation to the court. As a worker, you'll want to make sure that you've documented the active efforts you've made. It's up to you to prove beyond a reasonable doubt that the removal or TPR is necessary. Review the handout created by the Bureau of Indian Affairs for more examples of active efforts, and consult with your local attorney and the DSS Division of Child Welfare Programs and Policies for additional guidance. And work with tribal representatives. The tribes want the best outcomes for their children just as we do. The tribes can help you with your active efforts. Thank you for watching this training on the Indian Child Welfare Act. Your work to keep Indian children connected with tribes can help further the best interest of our Native children. Talk with your supervisor if you have any questions. And never forget that your DSS attorneys are ready to work with you in this legal arena. Like all Americans, Native tribes like the Catawba want the brightest future for their children.
I am Catawba.
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 We are proud Catawbas.
We are Catawba.
Please ask the question.
Ask the question.
I am Catawba, and it is important that you ask the question.
Thank you for all you do for our Native American children.